My name is Bob Rucker. I'm from the Circuit Executive's Office in the Ninth Circuit in San Francisco. I'd like to welcome you to the afternoon part of the hearings, and thank you very much for coming, and particularly the witnesses before us here. Let me say that I'd like everybody to remember to turn their cell phone off, or at least on vibrate. If you would mind doing that, please, right now. And for those of you who are testifying before us, I would ask you to speak directly into the microphones. They're somewhat directional, so you'll need to get fairly close to them to be able to be heard. We are streaming this live, and it will be recorded as well, so we really do want to have the record complete. So if you would have those microphones before you. We're going to go right into this without me giving much of a way of introduction, other than that to thank you. I will introduce the people here on the panel who will be doing the initial questioning. To my immediate right is the chair of our CJA committee. This is the Honorable Judge Cardone from Western Texas. Immediately to her right is Judge John Gerard from Nebraska. To my left is our attorney representative, Mr. Chip Frinsley. And to his left is Mr. Reuben Kahn, who is the community defender from the Southern District of California in San Diego. And what I'd like to do is begin with statements from you. We've read your written testimony, so we'd like for you not to read from that. If you would just give us about 5 minutes of opening statement about comments that you'd like to make, and for us to sort of use as a jumping off point. And Mr. Cohen, I'd like to begin with you, if I may.
Thank you, Doctor. I'm probably not the most loquacious attorney, and I'm going to be quite brief with you today. I've said a lot in my letter, but I would like to make a statement about at least a couple of the points that I think are very important. First of all, a little bit of background. I've been on the panel for about 20 years. I think I got on the panel in 1994. I graduated from law school back in 1988, and for a couple of years I worked for a small civil litigation firm. We mostly did plaintiffs' business litigation, securities, mostly suing stockbrokers for churning accounts or for having unsuitable investments. I started doing criminal work when I got out on my own after leaving that small firm. And I found that I liked the criminal work. First of all, it wasn't contingent fees. I wasn't losing nights' sleeps over whether I would be paid or how much time I would put into it and how much of my own money I would put into it. I was on state lists at that time, and the state rate was about $35 an hour in the mid-1980s or late 80s, early 90s. A friend of mine, Dan Feiner, worked in my office, and he hooked me into federal work. And I soon got on the panel, started as doing appeals and habeas, which I thought was a great way for me to learn from other experienced attorneys by reading their transcripts and reading about the law. And I learned to love the work. I haven't looked back since then. I've maybe done a couple of civil cases in the past 20 years. So all criminal defense. My mix is split between retained and federal criminal appointments. I no longer take state criminal appointments, primarily because of the money. Quite frankly, I would do more state court appointments because there are more trials there, and there are in federal court, but the money is just prohibitive. I think it's only $40, perhaps $45 an hour in state court here in Oregon. So I got onto the panel in '94. Steve Wax was our federal defender. It was a very well-run office. Steve, what I didn't know is Steve had really set a culture here. There was an ingrained culture of working hard on your cases, working real hard, and I made that point in my letter when I once asked Steve about an appeal that I was working on, and I just couldn't see any issues in it. And I told him that I was thinking of filing an Anders brief, and Steve looked at me and said, "Tom, in my 20-something years of practicing, I have not filed one Anders brief." And I went back and looked harder and found an issue. The court didn't laugh at it. The client was pleased that he had an attorney fighting hard for him. So that was the culture that Steve set, and it's continued with our present leader, Lisa Hay, at the Federal Defender's Office. As you've heard from other people who have testified, the Federal Defenders acts as the panel administrator. And this is the main point that I want to try to make here, is I think it works really well. You've heard about the department, the panel, I think it's 3 people in the CJA office who help to manage our cases and work on our vouchers and talk to us about whether or not they're appropriately supported. There's a glass wall, so to speak, between that office and the rest of the federal defenders for confidentiality purposes. But once we do work with them and once we get our voucher in or our request for an expert, if they believe that it is a reasonable request, they will pass it on with a recommendation to the court that we get the help that we're looking for. And I'm rarely, if ever, turned down. I can't think of an instance where a judge has contacted me and said, Mr. Cohen, I'm not going to approve this. I don't think it's reasonable. I've had a couple of instances where judges have called me about bills because they didn't understand, for example, who the bill was for, because the expert may have been billing under the name of his firm rather than the individual, and the judge got to know the expert as the individual and not the firm. I think that this helps in a number of ways by having the Federal Defender's Office act as our agent, in a way, to help us get the funds, the resources that we need to fight the cases. As I understand it, the Federal Defender's Office, each of them has their own pot of money, and they have to be stewards of that money and budget for their own cases within that office. We, as panel attorneys nationwide, have a large bucket of money for the entire country. And the judges, if they approve our bills or our requests, it's going to come out of that one big pot that is for everybody, all the CJA panel attorneys. My thinking is, in this district, I believe that once the judge receives a recommendation from the Federal Defender's Office that this is a reasonable request for service, they almost always pass it, because by giving that recommendation, the Federal Defender's Office is essentially saying, Judge, this is something that if one of the attorneys in our office had requested, we would have said yes. And so it helps to level the playing field. And while there is no rebuttable presumption, I think it's something that I would recommend, that if other districts were to follow this model and have their federal defender act as the panel administrator, if the judge were to receive that, they should approve it, because it's their federal defender who is telling the judge that, Judge, this is something that we would approve. We're asking you to approve it because we want the panel attorneys to have the same resources that we have. Sure, we don't get the money quite as quickly. There is the $800 that we can spend on an unauthorized basis, but that's for the entire case. And if you get wrapped up in a big case, that first $800 is going to get used up pretty quickly. So I would make another recommendation that $800 limit be changed, either for per provider or to a much larger limit, so that we don't always have to be taking the time to put in a request to get the services that we need, particularly if we have good reason to believe that it's going to be approved. Should somebody be working on a case and they're going on an unauthorized basis until the approval is made, or the disapproval as it may be, they can order that person to stop the work and pay them for what they've done already. It seems to be a very small price to pay so that we can get our forces into action quickly, similarly to the way the Federal Defender's Office is able to get their investigators or others, interpreters, on the case in an immediate basis. Third, I want to make a point about the CJA rates. And this might go back to the sequester, where we got hit with a $15 an hour hit, and it was never made up to us. There have been years since that time where there was an opportunity, for example, if we had gotten a $5 raise over 3 years, we would have been paid back the $15 that we lost over 1 year. But in a larger sense, we are underpaid when we compare ourselves to our colleagues at the U.S. Attorney's Office. And I did put into my letter what I could make from publicly available information as to what I think the compensation is for salary and benefits for an assistant United States attorney here in Oregon who's practiced for 15 years or more. And I forget the exact number because I haven't looked at it in a while, but our rates would be up close to $200 an hour if we were to work about 1,500 hours of billable time a year. So we're operating at now 129. I think that is just, we're being substantially underpaid. You know, maybe because we have bleeding hearts and we're willing to do the good work, the hard work, but it should be fair here. If we were paid more, we'd be able to have more money to spend on resources that we need, the software, the technology, et cetera, and the training to be more up to date on this stuff. As I've heard from other people who have testified over the past few months, cases have changed over the past 20 or 30 years. As one judge from South Carolina mentioned, when he was on the panel many years ago, he went back to find an old file, and I think he said it was 20 or 30 pages long. Now we're talking about boxes and boxes and filing cabinets and hard drives is what it is. So while our CJA rates have gone up, generally trended up over the years, my understanding of the way that they've gone up is that it's been based upon, the total case maximums that we have has been based upon the increase in the rates we have. So if the rates have gone up 2%, the total maximum amounts have gone up similarly 2%. It's taken into account nothing about the change in the complexity of the cases. These are different cases than they were even 20 years ago when I first started, and I don't think that the case maximums reflect that. It should be quite a bit higher because I think that what these case maximums have the effect of doing is having this anchoring effect that judges or other people who are looking at them see them as some sort of magical anchor that they think we should stay at or under in a case. And I've heard that other panel attorneys from elsewhere in the country are concerned or even scared to bill above that because they're afraid of getting cut or it's going to take longer to get paid. So I think some changes should be made there. I've talked actually longer than I thought I would, but I'd be happy to answer any questions when we get around to the question and answer period. Thank you.
Thank you, Mr. Sueda.
Thank you, Dr. Rucker, Judge Cordone, and other members of the committee. A little bit of my history. I started as a deputy county prosecutor in Spokane, Washington. 1981, I went into private practice, and I thought I should become admitted to practice at the federal court. So I went down there, and Bob Valquist, who was the clerk, gave me the application, and he knew me a little bit, and he said, you need to go on the panel. And so I did, and I've enjoyed it ever since. At the time, the panel rates were $20 per hour for out-of-court work. This is 1981, and $30 per hour for in-court work. At that time, we had one active judge. Now we have 4 active judges and six senior judges. I've been privileged to become the panel representative for the district, and my predecessor was Judge Peterson, who you heard this morning. So I've been the panel representative for a few years. In that way, I've been able to meet Tom and Jennifer at national conventions. I've been very honored to be the Defender Services Advisory Group representative for the Ninth Circuit. I'm elected by the other panel representatives to that position, and in that I've also had the privilege and honor of working with Mr. Frensley and Mr. Kahn and Catherine Rowe. I was also honored to become a member of the Ninth Circuit Oversight Committee, in which I had the honor of working with Judge Fisher and Dr. Rucker. This has really kind of become a vocation for me. Outside of the panel work, it's kind of a way for me to have done some pro bono work, and I feel very strongly about the need for the independence of the defense function. And I don't think that we have that today. And in fact, I think in the recent years, any semblance of independence has been greatly eroded. The Defender Services should return back to at least at a minimum of a directorate. I don't think that's enough, but it's at least a step in the right direction. They should be independent of the judiciary. I think even as a directorate, they are limited in the types of positions they can take and the statements they can make, because they have to be in line with the general protocol of the AO. And so they're, even as an independent directorate, they're hamstrung in that way. I believe that the defense function should be governed by an independent board of directors. It can be within the judiciary. It can have members of the judiciary be on the board, but I don't think it should be limited by as a joint effort in getting the judiciary budget. In other words, right now, they're governed by the budget committee, by the executive committee. They've lost the function, the staffing from the Defender Services Committee has been lost. It was given to the Judicial Resources Committee, and that was done as a cost-saving measure. And they did a long study, a work measurement study, and lo and behold, instead of saving money, the result of that study was that Defender offices across the country are understaffed, and they're in the process of hiring additional people. The panel members are particularly at a disadvantage. I learned in law school, and especially in the state system, you can't have ex parte communications with a judge. None. But you do in federal court. And I think that that's wrong. I don't think that a panel attorney should go to a judge to ask for an expert and possibly disclose defense strategies that haven't been fully worked out, give out confidences that from your client that you otherwise would never tell a judge. And I think it's also abusive the other way. I think that panel attorneys can abuse the system by trying to sell their case to the judge. And there's no parity in the expert system. Dr. Rucker and Judge Fisher, when we were on the committee, the Ninth Circuit was attempting to do a study to see what the presumptive rates should be for experts. And Dr. Rucker's employees were successful in getting records from U.S. Attorney's Office, Federal Defender's Office, and from district courts in the Ninth Circuit. And it was across the board, a broad spectrum of categories across the board, all these different categories. It was basically uniform. The U.S. attorneys paid the most for their experts. Next came the federal defenders, and the least paid experts were those that were employed by panel members. The district judges also have too much power in determining a panel member's pay. There's more emphasis on budgets now since sequestration. In my district, we're required to fill out a CJA Form 26, which becomes like a little mini budget. We're supposed to forecast what the entire case is going to cost. To the end, it's sent to the circuit, and the circuit gives approval on the proposed budget. The defense function should not be controlled by the judiciary. We shouldn't be controlled by the myriad of judicial committees there are. So I would just end there and just say that I'm a strong believer that we need to have an independent defense function. The courts do not control the prosecutors, and they shouldn't control the defenders.
Thank you. Ms. Nakaoka.
Thank you. Good afternoon. I'm from the District of Idaho, and I'm standing in for Kathleen Elliott, who is our CJA rep, who could not make it to this hearing. So I apologize that I don't have the depth of knowledge that Ms. Elliott would have brought to the panel. So there you go. I'm just a CJA attorney. The District of Idaho, and I want to start with just some facts. The District of Idaho has 67 panel attorneys. We are divided regionally by location in the state. So we have a North Central division that has 14 attorneys. The Southern division, where I'm from, has 37 attorneys. And then the Eastern division also has 14. The panel is selected by a selection board that meets every year to review applications. The board is made up of the federal defender, Dick Rubin, the CJA rep, Miss Elliott, and the judges and a member from the clerk's office. I don't know what really goes on in the selection process. We are required to have a minimum of 3 years of experience in federal court with knowledge of the CJA voucher system and the e-filing and, the list of what you would expect attorneys in federal court to be able to do. The panel, I'm told that the selection committee makes every effort to make the panel as diverse as possible, given our lack of diversity in Idaho. I think the panel reflects that lack of diversity. Of 67 attorneys, there are, I think, 11 or 12 women, and maybe 2 or 3 racial or ethnic minorities. The panel plan for Idaho calls for a 25 to 75 ratio, with 25% of the cases going to CJA attorneys and 75% going to the federal defender. I think typically the CJA appointments exceed the 25%, and that's, I think, due in part to the multi-defendant cases that we see more and more. In 2015, I'm told, the CJA appointment was 40%. And so that brings me to the testimony that I submitted to the committee in my written form. I raised essentially 3 issues that I thought should be addressed by the committee. I'm sure there's so many more. But that was the judicial involvement in the appointment, management, and compensation issues, the adequacy of compensation for CJA counsel, and the quality of representation. And I think it's important, like in Idaho, if you look at the fact that 40% of the clients are being represented by appointed counsel, CJA counsel, that's a good percentage of people who are getting funneled through the system, and they are not getting access to the services that the federal defender has. And they should not be deprived of those services just by luck of the draw. Our federal defender is excellent. They are staffed with incredible attorneys. They have incredible resources, and they do a great job. And I think that there's a consensus in Idaho that the CJA panel attorneys don't match up to the federal defenders for obvious reasons. I agree with other panel members. I think the case maximums are an albatross. I think they set a standard, maximum standard, where I think there's a danger that that's the expected, that's what the attorney is expected to meet, regardless of the case. And I think that's unfortunate. So I guess what I'd like my message to the committee would be is, as a CJA attorney, my fundamental duty is to represent my client, and that should be my only duty. And I feel that the way that the mechanisms are in place now, that I'm required to have also a duty to the court to keep fees down, to deliver representation in a way that doesn't raise eyebrows. I don't think that every attorney caters to that sentiment. I think we try very hard to not cater to that, but by setting maximums and caps and having judges review our billing and having them sit on the panels conducting the selection, you really create an atmosphere where the attorneys have loyalties both to their client and this subtle pressure to please the the courts. And I think that's inappropriate. It doesn't serve anyone well. So I thank the committee for doing what you're doing, and I hope that there can be some solutions that come out of this in the long run that free up CJA Council, give us the resources that we want, give us the ability to access them quickly like the federal defender has. Literally, I want what they want. They have. I want the resources that the federal defender has. Thank you.
Thank you. Ms. Horwitz?
Thank you, Doctor, and thank you to the committee for undertaking this thorough investigation of representation under the Criminal Justice Act, and for inviting me to testify today. My name's Jennifer Horwitz, and I've been on the panel since 2002, but I am probably one of the newer panel representatives. I'm just moving into my second year of my 3-year term. I tried to provide you with a fair amount of background information about my district in my written comments, and some of the things that may be different in my district than other districts, such as our standing committee. And if the committee has questions about those things, I'd be happy to try to answer them. What I wanted to try to do in my presentation here was just really drill down on one issue that I raised in my written materials, and that the attorneys in my district care passionately about, because it's really about resources, it's about parity, it's about quality of representation. It brings all of those issues into focus, and that's the issue of the statutory maximum and why this is an insufficient presumptive amount for probably any of the cases, but my experience really covers federal felony criminal representations. So what I really want to talk about is why, in my view, every case, I agree with the other panel members that the cases have become more complex over the years that I've been on the panel. We've seen bigger cases, more multi-defendant cases. But I want to talk about why every case really has the potential to exceed that presumptive amount, and why this is even true for what I would consider a garden variety representation that doesn't appear on its face to be complex or extended. In preparation for my testimony, I looked at attorney vouchers in my district in the last fiscal year. And there were 601 CJA 20s and 30s submitted, and 141 of those went to the circuit for approval, so about 23% were over. I also looked at my own practice since 2002, all of the cases that I've done, and about 33%, just about a third of my cases have been billed over the statutory maximum. And what I did in preparation for today was I looked back at my own cases where my billing exceeded the maximum. And I tried to set aside the cases that, to me, clearly were complex and extended cases, the large multi-defendant cases, the cases with voluminous discovery, with a lot of wiretap evidence, cases that went to trial, or cases where a number of legal issues were litigated. And what I wanted to see in my own caseload was why cases that appeared to be much more straightforward sometimes demanded more than the 77 hours of work allowed by the presumptive statutory maximum. And overwhelmingly, just looking at my own cases, it was really because of what the particular client needed in the representation, especially in terms of meeting with me and having contact with me. So I've been in practice for over 20 years, and in my view, of all of the criminal defendants that I've represented as a state public defender, in private practice representing clients who retain me, and on CJA cases, the most difficult attorney-client relationship to forge and maintain is one in which I'm appointed under the Criminal Justice Act. And there are several reasons for this. I think it's really important for the committee to understand that as far as many of our clients are concerned, we appear in their lives as part of the same system that surveilled them, seized their car, listened to their phone calls, searched their home, pored over their computer and bank records. We are part, in their view, when they meet us, they see us as part of a system that will not reveal witness statements in time for them to consider what that evidence is when they're trying to decide whether to take their case to trial or not. So when we first meet a client and introduce ourselves, they don't simply trust us because we've said, "Hi, I'm Jennifer Horowitz. I've been appointed to be your lawyer." We have to earn that trust. And I guess I'm here to tell you that doing so can be a hard-won proposition. So how do we do this? We do this by spending time with them, by getting to know who they are, their background, where they came from, and how they arrived at this point in their lives where they're facing a federal indictment. We do this, if they would like us to, by meeting with their families, their wives, their boyfriends, their adult children, and sitting down with their loved ones and telling their loved ones what is happening with the case, giving them a roadmap of what to expect. We win our clients' trust not just by reviewing the evidence in the case ourselves and understanding it ourselves, but by being so familiar with it that we can show our clients that we really have a mastery of the facts in the case, and we can lay out for the client not just that there is an accusation, but what it appears to be built on. And we earn our clients' trust by explaining how the federal sentencing guidelines work in all of their complexity, along with concepts like cooperation, substantial assistance, mandatory minimum sentences, and safety valve. And in my experience, we're mostly representing people who find themselves in the federal criminal justice system for the first time. So they're hearing how this works for the first time. My experience is that I've represented several people in federal court who have long criminal histories in state court. And even they have trouble understanding what this new system to them is about and understanding the much greater peril that they are in the federal system. It is even harder when we're representing people who are illiterate, who come from a completely different culture, who may not speak English, who are completely unfamiliar with our criminal justice system, who have learning disabilities, organic brain damage, or mental health issues. And all of these limitations that I've just listed here are issues that have come up in my practice with particular clients. So if I can take the time to form a trust relationship with, for example, a non-English speaking client with a third grade education and convince him that I'm truly his advocate and educate him about how the federal system works, then even if I exceed the statutory maximum bill in the case, I have likely saved money because when it finally gets to the point in the representation where I say, hey, the evidence against you appears to be pretty overwhelming, and this plea is the best I can get you, he will believe that I'm not just trying to wrap this case up in a way that's easy for me or the least amount of work, but that I really am advocating for him. And I guess what I'm here to say is that getting to that moment in the representation takes time, and it takes building a relationship, and that can't always be done with the other work in the case for a total of under 77 hours. Thank you. Thank you so much for considering my testimony, and I'm happy to answer any questions when it's time.
Thank you. Help me, is it Mr. Hooverstall?
That's right. Thank you. If you read your materials, I'm the guy who got his voucher cut for bailing his dog, my client's dog, out of the dog pound. I guess the first thing that I want to say is that I've been practicing on the CJA panel for 26 years. The first jury trial that I ever tried was a 5.5-week long jury trial in front of a federal judge in Helena. And I've been doing it ever since then. I yesterday sat back in the panel and listened to the testimony. In the afternoon, went to my hotel room and I listened to the testimony by the live stream. I did the same thing this morning. And this, in my opinion, is a way you can solve the remote detention issue and the attorney-client communications problem. And I'm going to tell you by giving you a little bit of background. I one time tried a case in Billings. It was a federal jury trial. And I argued to the Ninth Circuit at the same time in Seattle. I was literally at the podium cross-examining a witness, and 10 minutes to 10, the district judge said, "Counsel, we're going to take a break." Turned over and looked at the jury. "Ladies and gentlemen, we're going to take a little longer break than normal. It's going to be about 45, 50 minutes. And so I got up, grabbed my briefcase, walked across the hall and went to the bankruptcy court. And right there on the monitor were 3 appellate judges, a panel of 3 judges in Seattle. And I argued that appeal to these 3 appellate judges in Seattle. And it was exactly as if I were in Seattle, standing at a podium, arguing a case to the Ninth Circuit Court of Appeals. At the end of the case, it was submitted. I went back to the district court. Witness got back on the stand, and I continued to cross-examine that particular witness. So this is the point. In Montana, and I'm sure you've heard this testimony elsewhere, there are these huge distances. There's this remote detention issue. It creates problems with the attorney-client relationship. I'll get appointed, I'll drive more than 500 miles to see a client, and he's angry, he doesn't trust me, these other lawyers, they were trying to, sell me downstream or whatever. And we talk, we develop a relationship. Then the next thing I know, "Hey man, you're not taking my collect calls from the jail. When was the last time I've only seen you once. I need to see you more often." The response will be, "Sorry, I was flying to Seattle because I had a Ninth Circuit argument on Tuesday," which incidentally I did. And then Tuesday afternoon, I flew to Portland to attend these review committee hearings. And so I wasn't in the office to take yours. And they're angry. They don't think that I'm doing my work. They don't trust me. They file complaints with the district judge. They file complaints with the state bar, with disciplinary counsel, because I'm not there. And I'm not there because the attorney-client, the ability to engage in these attorney-client meetings, as Ms. Horowitz was just talking about, talk to your client, review discovery, can't happen, or it's exceedingly difficult to happen. So this is the solution. Like the time when I argued to the Ninth Circuit and tried a jury trial to the district court, we have the ability to engage in attorney-client meetings using technology. I heard Judge Rankin this morning talk about in the District of Wyoming, they have a standalone computer in this jail cell, where where defendants or accused people can look at discovery. They get a CD, there might be things that are, limitations. They can't print them out, but they can look at it. In the District of Montana, we have a local rule that when a document is designated as sensitive material, then it can only be reviewed in the presence of counsel. We can't give it to the client for him to review. And so that creates a huge problem in terms of talking about the weight of the evidence with the client. It talks about the strength of the government's case or any potential legal or factual defenses that we might have. Because I got to drive 500 miles to see this guy. If we had a system, and I do it all the time in my office, I have a computer here, a computer monitor here. and I have one here and another one here. I can conduct a Skype conference with a client who is located in wherever, Maryland. I do a lot of Court of Federal Claims work, construction type cases. So I can talk to a guy using Skype on this monitor, and then I can say, well, look at this doc, here's the contract. And on the other monitor, I'll have a PDF file. He can look at it, I can look at it, and we can have a discussion about that. And as Judge Rankin was, referring to in the District of Wyoming, having a standalone computer in this jail cell, it seems to me that would be an easy fix for this remote detention issue. It would be an easy fix for these elevated travel hours that CJA counsel have. I mean, last night, FaceTimed with my wife before I went to bed. All you got to do is have an app, develop an app so that you can send a client or they can communicate with you by email, and you say, okay, I'm in court or I'm in meetings, we'll do a video conference tomorrow at 9. Or you can do it, by cell phone. I can file documents from my hotel room in federal court. I can file motions, I can file briefs, I can submit an e-voucher. Why can't I have an attorney-client meeting using my laptop in my hotel room while I'm here in Portland and my client's locked up in Wyoming? So this is the solution. I think that it's a problem that's created by the executive branch. The executive branch through the U.S. Marshal Service decides to house these guys in, Wyoming or in Shelby to save money. Why can't they that creates the problem, why can't they cure the problem by creating a room where, clients can meet with attorneys by video conference. You can email to them the document or send them a disk so that they can look at it, so that they can't, print it out and show it around to the other inmates in the jail who the government cooperating witnesses are, or whatever. And you can have substantive attorney-client meetings discussing the weight of the evidence, discussing the documents, discussing, factual defenses, legal defenses, and the problem that's created by this remote detention, this non-accessibility or inaccessibility, goes away because you're available. We have the technology, we should use it. And that is my proposal for the solution to this particular problem, the remote detention issue. I think all you have to do is send a report back to the Chief Justice saying, why don't we do an RFP? An RFP in construction language is a request for proposal. Why don't we send an RFP out to the IT firms and tell them to develop an app so that attorneys can do that, CJA counsel can do that. So that's my suggestion.
Thank you. Mr. Khan, would you like to begin the questions?
Thank you. Mr. Cohn, let me start with you. You began, let me pull this a little closer because this doesn't pick up. Let me start with you, Mr. Cohn. You began talking about the initial limit on experts, the $800 that you could spend without getting permission, and you talked about how that needed to be raised. And I have a couple questions for you about that. One, can you suggest an amount that you think would be adequate? And two, should we be considering different sets of initial limits for different types of experts? For instance, should we consider a much higher initial limit for investigators, because in almost every case you're going to need to get an investigator going on your investigation, or interpreters or something like that? How would you recommend structuring this if you were going to change the statute?
I think that the easiest way to do it would be to make that $800 limit applicable to each service provider. An investigator out here, I think they're charging $65 an hour generally for investigators in the Portland area. That gives them 10, 11 hours, which should be, I think, plenty of time to go ahead and get started on a case. If we get our authorization back from the court in a timely manner. It
Can I
just
ask you, what do you think of as timely? What,
Well, I think once we send it over to the Federal Defender's Office, the turnaround over there should be within a day or two. And we should have gotten a call back from the Federal Defender's Office with any feedback, letting us know whether or not, and they do this, saying, Tom, I'm not sure, why do you need 100 hours for this paralegal? Do you really need that much? If you do, you're gonna have to put some more information about the plan, how you plan to use that person. So I think that should come back within a couple of days.
okay, so I'd like you to imagine for a moment that you don't practice in the District of Oregon and you practice someplace where you are not likely to get any response in less than 2 weeks. What would be a reasonable limitation in that case?
I'm thinking more not on a limit as much as getting
The
back.
initial authorization that you don't need to have approval for.
$1,500. I'm taking a stab in the air at this, but I think what would be a better way to go about this is if we proceed on the assumption that this is a reasonable request and it will be approved. If it's not approved, we're going to have a duty to tell that service provider, hey, hold off on any further work. But I think that the danger of going too slowly is too great, whereas if they did proceed without getting later authorization because somebody deemed it to be completely unreasonable, then going over that amount probably hasn't gone over the $800 too much, unless you're talking a whole long time before you get information back about your authorization request.
Okay. Pete, can I ask you the same questions? Do you have any thoughts about how we ought to structure that initial authority to retain an expert?
I would say like $2,000 when you're talking about an investigator. I think it would be,
Investigator, interpreter, or sometimes you need a psychologist right away, any of those.
I think $2,000 would give you enough to at least get somebody, even a psychologist, started looking at things and give you an initial impression.
Ms. Nakaoka, same question for you.
I just really don't know that setting any maximum or cap really solves the problem. I think the initial issue is whether or not we are all officers of the court. It's whether you trust us to make, in our judgment, a good assessment of what our case needs in order to be defended properly. I know that sounds like I'm asking for the sun and the moon and the stars, but I don't think that most or any, really, CJA panel attorneys take these cases with the hope of exploiting the system. We are trying to do a good job. We need the resources to do the job. The $800 cap is ridiculous. And so that forces us to triage what we're going to do with the hope that we are making the right decision initially, and knowing that we don't have the ease of access to the services. We'd have to run everything by the court. So I'm hesitant to set a number amount on it. But certainly the $2,500, that is, the authorized cap before it goes to the. I agree with Mr. Cohn. If it were $800 per service provider, but I would bump it up to $2,500 per service provider, not expecting any attorney to use that in every case, but just giving us the freedom to be able to use the services quickly and efficiently.
Ms. Horowitz, can I put the same question to you and actually expand it a little bit? Because one of the things I think would be helpful for our record are some examples, and it may come back to the others of you, of examples where the inability to get your expert going right away hampered your defense of the case. So if both of you could give me an idea of what you think might be a reasonable approach to this issue, as well as some examples of the problems the current limitation causes.
Well, I think I also am lucky to practice in a district where we have a CJA administrator who helps us kind of streamline our requests and makes sure before they go to the judge that they're persuasive requests, and then advocates for us somewhat when the request gets to the judge, and also makes sure that it's turned around in a timely fashion. So I'm not sure I can think about a situation where I had such a long delay that it hampered my ability to proceed or represent the client well. But with that said, you know, it's a lot of busy work and extra work for us to keep going back to the court and applying for funding, especially if we have a bunch of different issues going on in a case. So my suggestion would be that there not be an aggregate amount, that there be a set amount for each service provider, and for providers like investigators, paralegals, interpreters, it be in the neighborhood of $1,500 or $1,600, and that it be a higher amount for mental health providers, neuropsychs, people like that, which are a lot of the experts that I end up bringing into a case that's not going to trial.
Mr. Huvestal, I think you may be the one person who doesn't have a CJ panel administrator. Is that right?
That's correct. What
Tell
we
me
do,
about your experience.
well, what we typically do in our district, you know, I'll go and meet a client. I can see something's not right there. And although it might not amount to a competency defense or competency defense or, you know, responsibility, I'll approach the court because I want a diminished mental capacity evaluation. But in our district, that doesn't happen. What they typically do is say, well, why don't we just send him to Seattle, to CTAC here, and he can have basically a competency evaluation conducted. And so I don't get the kind of evidence that I want for sentencing purposes, you know, like a diminished mental capacity. So the question, I mean, to answer your question, I think it should be higher, at least $3,500. That's what they charge. Why would we limit ourselves so that we have to go back to the court, file another motion? $3,500 for a psychological evaluation, minimally. I mean, typically it's more than that, $5,000.
But you're saying you can't get that in most of your cases anyways. You're simply
Yeah,
denied the
in most of
request.
my cases, that's correct. In most of my cases, they say, let's just send them out to CTAC, which is problematic in other ways because then you get a call from the evaluator, you know, in a couple of weeks, and he wants information about why you requested it. And so you have to have this discussion with the evaluator, and you eventually end up seeing your comments in the report that goes to the court. And so, you know, that's inappropriate as well. So I don't like the way the system, at least in our district, is held. I would like to be able to obtain my own psychologist for my own purpose so that I can use it at sentencing, for example.
And what do you think of the idea of having a panel administrator who's part of or connected to the Federal Defender Office?
Well, I can tell you that our Federal Defender's Office is excellent. They are extremely good lawyers. They are extremely helpful. They, I can't think of a bad thing to say about them. So if there was a panel administrator attached to our Federal Defender's Office, I would have full faith and confidence in whatever they could do. I know that they would do what they could to help us.
Do I have time for another question? Ms. Nakaoka, I'd like to ask you something. You said something in your initial statement that you want what federal defenders have for your clients. And I understand you were speaking to resources, but that brought up in my mind something else. In many ways, when I think of what we have that's most special in our office, it's two things. One, that we do nothing but practice federal criminal law 7 days a week. And two, that I have colleagues all around me who I can always go ask a question. Now, the second's not really possible to replicate for private practitioners, but the first you could provide if we were to shrink panels further and increase the number of appointments. What's your reaction to that idea?
I think it's a good idea. I think the number of appointments, if that number increased, you would necessarily increase the expertise of the attorneys getting those appointments. they'd be in federal court more frequently. I think the fewer panel attorneys, I think you would also encourage more professional camaraderie because there are fewer attorneys doing the panel. They get to know each other. We don't have in Idaho a CJA administrator, and we don't really, we're like most Western states, we're spread out. So not all of the panel attorneys know one another. We don't frequently see each other in court. I think the average appointment is, I've heard, I don't know for a fact, is 3 or 4 appointments per year. It may be more depending on which division you're in. So there's not a lot of opportunity, as you said, for us to have the intellectual exchange that you have at the federal defenders. I know that would be a very unpopular decision for the local attorneys who do the CJA contract, or are on the panel, because there's a wait list for the panel, and a lot of people would like to be on it. So to restrict the number would not be a popular decision, I think, for the bar.
Pete, you've got a sense of the national perspective on these things. What do you think about that idea? Shrinking the panels to make panel lawyers essentially full-time federal criminal practitioners.
I wouldn't say they would have to be full-time, but I think that they have to get at least 5 or 6 appointments a year that are real appointments, because I think it trains them. They have ongoing training in federal criminal practice. They become more efficient. There's an efficiency that would go along with it. So, having a full-time practice and CJA work would be fine, but I think that the point you have to get to is what the Vera study said, which was 5 or 6 appointments a year, as I recall, and I think that's the point where you really get a benefit to the system, or it becomes more efficient and more beneficial to the client and also to the judiciary.
One last question for you, and then I'll turn it over. How many appointments on average are you getting a year in your district now?
It's varied. I have, when Judge Peterson said they were giving 2, I had to think, right now I have 3 active cases and 1 that's on appeal. So I think my experience has been a little bit more than 2 a year. There's been years where we would get 5, 6, 7 appointments, but that's dropped in the recent years.
Mr. Cohn?
Yeah, thank you. Ruben, just to get back to your original question, one of the things that we do here, maybe they do it in other districts too, which I've found does save some money and some time, with respect to interpreters, which we use quite a few of them. There are a lot of Spanish-speaking people here in the federal criminal system. We put in one request, an authorization for $2,000 or for up to $2,000. That doesn't necessarily have to go to the same interpreter, because it's difficult to find an interpreter having the same schedule that you have and fitting in with it. So we can use any interpreter who's available, and they can all go off that one $2,000 voucher, which saves us quite a bit of time in terms of, reapplying for somebody new or trying to manage our schedule with a busy schedule of an interpreter. As to panel size, we just did a review, first time in 4 years here. And there's some natural attrition, but there's some friction, because I'm of the opinion that we should be getting a minimum of 6 significant appointments, trial level appointments, not just supervised release violations or something like that, in order to keep up our expertise and our interest and motivation and enthusiasm for wanting to practice, or at least work primarily in federal criminal court. There's been a reduction in filings here. It's been trending downward for the last 3 or 4 years, I think. And I don't know if that's going to continue, but we've just added a number of people to the panel to get it back up to the same size that it was 4 years ago. And I'm concerned that the number of appointments is going to drop. And I think that that could be a problem for morale amongst the panel members. and for interest in wanting to be a panel member down the road, but we'll see.
Thank you. Ms. Horowitz?
I'm glad you asked for my feedback on this, because I actually think we would be doing a disservice to our clients by having our panel members just do federal work. And that isn't to say that our clients aren't being well served by the Federal Defender's Office who's doing that work full time. But I think the sweet spot is a minimum of 5 to 6 cases a year to stay proficient in federal practice. But I actually have had the experience, and I won't bore you all with the details unless you want to hear it, but I've had the experience in a few cases of feeling like I had an extra edge in advocating for my client and getting the best possible result, because not just of distant history with state practice, but because I'm currently doing a state practice, and I was able to bring that expertise and specific knowledge about how things work in state court, what the options would have been in state court, to the table. And so I think that's a benefit that our clients can get if they have attorneys who are very proficient in federal practice, but also know what's going on in the state system.
Mr. Huvestal, can you just touch upon that question?
I have at a minimum 10 cases I get appointed at least per year.
You're handling a substantial
Yeah,
number of
yeah.
federal
And
cases.
so in Montana, I don't know how much different we are. I think that the panel members that we regularly see, and unlike Idaho, we do see each other in court a lot, and we do discuss things. We have an annual meeting. In terms of the number minimum, yeah, I'd agree, six cases a year, big ones. I mean, cases that have the potential of going to trial, cases that might have a suppression issue or whatever, rather than just the revocation of supervised release or something like that.
Thank you.
Mr. Frinsley?
Ms. Horwitz, you addressed this issue about case maximums, and I want to explore that a little bit with you and perhaps the rest of the panel as well, because it's been alluded to in some of our previous hearings, but I don't think we've really sort of drilled down on it. So I want to take the opportunity, since you've highlighted it, to talk to you a little bit about it. And I guess I would start with sort of the first question. From the panel lawyer's perspective, what is the concern about hitting that case maximum so much more frequently now or sooner than what you might otherwise have done so?
You mean, why is the case maximum a problem for us, and why do we want to
Right.
do we want it
Yeah.
higher? Well, I think, I practice in a district that I think is more supportive probably than other districts when a lawyer does the work and goes over the maximum, and I think that often those vouchers are approved. But I think it sends the wrong message to the court, to the lawyers, and there's a real parity issue with creating a limit like that. And I actually, in trying to do my homework to be prepared for today, I actually tried to figure out where this number comes from. And I understand the number keeps changing as the hourly rate keeps changing to sort of keep step with about 77, 78 hours. But who decided that was enough? And I couldn't figure out the answer to that question. And I made calls to certain people that I was told might have the answer, and calls to DC. And I just, unless somebody can explain to me that that there's data to support that in most cases that's enough time, or that's on par with what the government is spending prosecuting these cases, I think it really sends the wrong message to have to justify myself, especially as the system is set up now, to the trial judge, why I had to go above that amount. So to me, it's a way of communicating to all of us, our clients, the lawyers, the judges, that these cases don't deserve more than 2 weeks of full-time work.
And so, the consequence, or one of the consequences at least, of hitting the max is that then you have to go to the circuit.
Right.
Can you talk a little bit about what concerns that raises in terms of both that justification you're talking about, the ability or perception of the ability of a circuit level person to evaluate that work, and then the time associated with the delay in the processing resulting in that.
Right. Well, we're also lucky because we do e-voucher, and that has sped that process up even when the bill goes to the circuit considerably. But, you know, we're already in a situation, I think we've got a great bench. I have a lot of respect for our judges, but, you know, we're in a situation even at the district level, and I know you asked about the circuit level, but even at the district level where the person trying to evaluate whether the time that we spent was reasonable, these are people who, you know, we have a judge who never practiced criminal law and became a judge. We have several judges who were government attorneys for their whole careers and weren't in private practice and don't know what the time it takes to run a business, the kind of overhead you're paying, all of that stuff. And it's even more removed when it goes to the circuit, and then the circuit, you know, really doesn't know what you've done other than what's in the bill. And one of the things we're trying to do is give our lawyers more information about how to explain their bills more and better and all of that. But it's simply a hardship, the delay, the extra work in justifying it. But again, I'm lucky in that I practice in a district where, and I looked into this before coming today, we haven't had many cuts at the circuit level when it goes up, but you've got to wait longer to get paid.
Yeah. So we've sort of identified the concerns and issues. So now let's sort of assume for a minute that that the statute didn't exist, that those requirements weren't there, and let's try to build it, okay? And with that backdrop and your experiences, I guess my first question would be, would you have a point at which there would be some sort of review of a voucher beyond a district level review? In other words, would there be some threshold at which, okay, well now it has to go to somebody other than the district level to make the decision? And this is like Fort Howard. There's no right or wrong answer.
Right.
I just want to know your answer.
Well, the reason I'm making that face is that you're also kind of asking, well, where does this function even belong? I mean, because your question assumes that it stays with the court and that the circuit level is the review.
Really
you
good
know?
point. Yeah, I mean, I suspect we'll get to that question as
Right.
well. But just, I really, though, I do want to focus on this cap issue,
Yes.
because that's, you know, again, it's an issue that's come up specific in your testimony that we
Right.
really haven't talked a lot about as a committee. So well, let's set aside for a minute, and it's a very important question. It's something the committee is very interested in, whether or not it stays within the judiciary. But again, let's just sort of look at this excess issue. And so, is there a number at which you think that it would be appropriate for there to be some level of review above a threshold review?
I do, but I can't give you the number because I don't have the data.
Okay.
I mean, I can tell you what I'd want to know. I'd want to know, I'd want information like what I brought to you today, and more from each district. What percentage of vouchers are going to the circuit and so therefore are over the current amount. And I would also, and I know this is very hard to figure out how to come up with a number, but parity is important. What is the government spending on these cases? And those are the two main things that I would want to know in order to set a number.
So let's, if I remember correctly, didn't you say it was about 23% of the cases that go to the circuit?
In the last fiscal year in my district.
Okay. Do you think that 23% number is right, or do you think it should be something less than that should be having additional review, or does that inform you at all?
Well, people may disagree with me, but to me, 23% is a big number for the exception. You know, that's not necessarily a number where you have the exception swallowing the rule, but you know, to me, an exception is 5%, 10%, and as a district, we were at 23%, and I consider myself a conservative biller with no voucher disputes, other than one where the judge said, I just don't want to pay you. I think you did the work, but your law partner was on a 4-month trial, and I just don't want to pay you. And 33%, I mean, that's a third in my own history. That's the exception approaching swallowing the rule.
Yeah,
to me.
so you're thinking somewhere 5 to 10 is
Yeah.
sort of the sweet spot for where there might be another look that needs to be had. What, does anybody else on the panel have any thoughts about that issue?
I would do a paradigm shift where get it out of the judiciary, and even attorneys that are hired by the district or the circuit, and get it into the federal defender's office or get some other mechanism. Because what you would be able to do in that circumstance is I think an attorney would be very free to discuss the case with that person, and there could be a dialogue that could be beneficial to the economy of the case, as well as to the benefit of your client.
So let's assume that were to happen. Assume that the judges were totally out and we adopt the Pete Schweda model and it goes to an employee of the defender's office. Would there ever in that situation be a situation where there would be an additional layer of review above that party right there?
I think that the additional level of review would be if the panel attorney felt that they weren't being treated fairly. I think that's the only time that you would have the additional level of review. And as to the amount, I think that you should determine somehow what the average cost of the case is. And then when you exceed the average or some percentage above the average, that's when you have to have some serious approval from whoever is looking at the vouchers and determining what should be paid.
Chip, if I may, as I think about that, it seems as though every bill that I've had that's gone into review has been approved. And practically every other one that I know of for attorneys in Oregon have been approved when it's gone on to that second level. So the only thing that's done is delayed our payment, and that's a problem. It's one of the biggest complaints that I have from panel members in Oregon. We don't have many, but I hear about that, the delay in payment. We all have bills to pay. We've got rent, we've got mortgages, we've got kids in college. People want their money. We don't want to wait 3 months for it. We don't get interest earned on it. So if they're going to really deny, it sounds like, from what I know, a very small percentage of those that go to review, why don't we look at the cap of where they're really cutting? Which ones are they disapproving of, and use that as the cap for cases, because those are the ones that are in serious trouble.
Anybody else have any thoughts on that issue? Yeah.
Just very briefly, in the testimony earlier this morning, the question was asked, well, has anybody's travel time, and I'm going back to this remote detention issue, has anybody's travel time ever been cut? No, it hasn't, but what it tends to do is approach to the case maximum more quickly. And then what we have to do is file a motion to designate the case as complex or as extended for whatever reason. And I'm not really sure what happens during the review process. My personal assumption was always that it goes to a law clerk, and the law clerk takes a look at it, and the law clerk makes the determination, writes a memo to the judge, and then the judge, I don't know what happens. But that's what I think happens. But I don't honestly know what exactly does happen. At the appellate level, I don't think, I've never had a problem. It's always been, I mean, at the circuit level, it's always been approved.
The appellate level is kind of like that beer at the restaurant last night called the Abyss, right? Yeah, sorry, Ms. Rhodes.
I just wanted to add one piece of information to my answer to your question, which is we review a third of our panel every year in a process that the standing committee engages in and provides a report to the court. And one of the things that the court wants to know about the attorneys that are under review is how often their bills exceeded the statutory maximum.
I'd like to follow up on that, if I may, before I turn it over to Judge Cardone. Are any of you doing any self-cutting so that as you're approaching the maximum, you decide not to go over the maximum, you know, so that you won't have to go up to the circuit and you can get paid more quickly?
Yeah, I've done it a lot of times. I mean, if it's only $500 or even $1,000 just to get paid, I'll cut my voucher. And I've had vouchers delayed for 6 months.
Because they went up to the circuit? Or are they just
No,
District court.
right.
just district? Okay.
I think from the District of Idaho, anecdotally, I think every attorney, every CJA attorney I've spoken to has cut something at some time or another for reasons, getting paid more quickly or feeling that maybe it wasn't justified. I heard testimony this morning, or was it yesterday, where attorneys are doing things that they feel the court won't allow, so they just cut it. They still do the service, but they cut it. So I think that, I'm confident across the board that we all cut our hours.
So is that really a function then to just get paid sooner, not have to be delayed, or do you think that you would be cut?
No, I think it's a combination of things. One, yeah, you don't want to have any longer delay than you are already experiencing, especially if you haven't already filed a motion for interim payment. So, but also, again, it's this tug of war of, wanting to do service for the court and not appear to be overbilling. I think, there's just a combination of pressures which sort of weigh the scale towards, encouraging, not expressly, but encouraging attorneys to meet those maximums. I mean, that's why there's a maximum, right? You're telling the attorney what that case should be completed in terms of hours.
All right, thank you, Judge Cardone.
I have a question for Ms. Horwitz. Ms. Horwitz, I heard you quoting data about the number of cases and how many went up that were excess, et cetera. And one of my questions for you is, where did you get that data?
I got it from Natalie Harmon, our CJA administrator. I asked her if she would get those numbers for me.
And and are you on eVoucher?
Yes.
So is it your understanding she got them from eVoucher, or does she keep them separately?
I'm trying to think what discussion we had about how she got those numbers. I think that she said she was going to use eVoucher to create that data, but I'm not exactly sure what search she ran. What she said to me is, in the last fiscal year, these are the number of CJA 20s and 30s, and this is how many went up to the circuit.
Okay, and approximately how long did it take her to get those numbers for you?
That I don't know. What I can tell you is we had a meeting where I asked her a number of questions, and she said to me, I'm going to get you this data. And I said, if any of this is a big burden on you, don't do it. Just get back to me and tell me, you can't do it. It's going to take too long. So, but we didn't define what amount of time that was.
Well, from the time you asked for it till the time you got it was approximately how long, I guess?
I think it was 2 days.
Okay. All right, the next question. You have no idea.
Rising, Judge.
The reason we're all laughing is we can get no data. Okay, so along those same lines, when we're talking about eVoucher, a question for all of you, because I heard a couple of you mentioned about getting about this whole issue of the vouchers and how much is the 9,700 it has to go up to the circuit, and it should be raised. And then you said, I believe Ms. Horwitz and I think Mr. Shweda talked about, it's a function of figuring out. I think what you said kind of is what I heard. Maybe what you said and what I heard are two different things, but it raised a flag in my mind. Is the average cost of a case. I have heard, the committee has heard some concerns about gathering that kind of data. The issue of, will eVoucher allow for this gathering of what should the average case cost, and we're not going to let people go above this average. Why are you billing above that average cost? So a twofold question, and I'll start with you, Mr. Shweda. If there has to be some way to figure that out, is eVoucher the appropriate way to do that? Should there be a function of averaging a case and then sort of using that as a measure of what a case should cost? And I think you've kind of answered this, but in whose hands should that be?
Pardon, the last part?
In whose hands should that be, and why?
Again, it shouldn't be in the court's hands. It should be either in the federal defender's office, because you can have the problem with doing it, you would never want to do it to the judge, and that's the system that we have now. I don't think it's fair to do it to the judge's employee, because if the judge asks, or maybe the employee goes and tells the judge, I'm getting these kind of questions. I think that there should be a confidential, frank discussion with someone that the attorney can trust, either someone in the federal defender's office, or develop some other kind of a system where we have an independent function. And I did not mean to imply that we should have benchmarks for cases. What I meant to imply is that when it becomes beyond the average case, then we should start having discussions about what do you need, why are you doing this, so that it can be justified and there can be some reason for doing it. So I certainly didn't want to this committee to think that we should develop average cases and that those should become benchmarks for, if you do a robbery, this is what a robbery costs, and you shouldn't go above what a robbery costs.
Well, but then I guess I still don't understand your answer, because I thought you just said if it goes above a certain amount, then we should start asking these questions. What are you saying there?
Well, it's different between saying, I think there's some circuits that I've heard where if you have a guilty plea, you never get over the case maximum. That they don't allow it in any way, shape, or form. What I'm saying is that when you get to the average, an average case cost, that's when questions should be that's when you should go ask for permission and say, this is the kind of case I've got, and these are the reasons why I'm going over the average cost.
All right. Anyone else? Ms. Horwitz, any thoughts about using e-voucher for that, or getting data from e-voucher, or who should have that data and how should it be used?
Well, I wish I knew more about what kind of data mining you can do through eVoucher, and I don't.
Well, let's imagine you can do all kinds of data mining. Who should do it, and how should it be used?
Well, I mean, I feel comfortable with the way things are in our district, that we have a CJA administrator who's part of the Federal Defender's Office. And so the way things are organized in our district, I would suggest that she be the one to do it.
All right. So should the judiciary play any role in any of that? Especially as it goes up to budgets that go over a certain amount or go up to the circuit level? Should all of this data, right now the AO is the one that's issuing out the e-voucher system, should that all be gathered at the administrative office? Any thoughts about where all of this should be held?
I mean, are you asking in terms of the committee's efforts to get a hold of this data and make decisions based on it?
No, I'm talking about, we're talking about a structure, right?
Okay.
At some point, we're going to make a recommendation. This is the structure.
Right.
And, it's right now it's in the judiciary at the administrative office. And so things like e-voucher, which affects CJA panel attorneys,
right.
There's data.
Right,
Okay?
no, and I would take that out of the judicial function completely, including at a level of review.
Okay, so where does that data go? Who should be able to hold that data and know what it costs for you to do a case and be able to work those numbers like you did?
The CJA administrator, who I think belongs under the umbrella of the Federal Defender's Office.
And how about national data?
Well, I mean, that sort of raises a bigger issue that I'm sure you don't want me spending a lot of time talking about, but I think there should be a CJA administrator in every district. They should be having conferences, and there should be somebody who's in leadership nationally.
For the CJA attorneys separately?
I think there should be, just like the CJA panel reps have conferences and the Federal Defender's Office have conferences, I think in every district there should be a CJA administrator. They should have conferences, and there should be a leadership structure within that entity.
Can I add to that? I read that there was a sort of a temporary study or test case where CJA supervisors were created, and I think that that would be a great solution for the West. For the West, if we had regional CJA supervisors who were familiar with the culture of the various regions and the needs of those regions, they could act as the voucher reviewing entity rather than the courts. They would have a better sense of what local cases require in terms of defending. They would be the buffer between the attorneys and the government, so to speak. I just think that that's something that's needed. And then the idea of using e-voucher data to try to determine what should be the appropriate amount to spend on a case, I think that assumes that the data is reliable. And I think if you take into consideration the fact that attorneys are cutting their own hours, you're going to underestimate what a case takes to defend.
Can I ask you a question? So if you have these CJA supervisors, if that were the structure we were to recommend, who would appoint the CJA supervisor?
Ooh.
Or how would that, would you elect them? Where would that person come from?
That's a good question. I haven't really thought about it. The CJA rep, though, I'm not even sure how the CJA rep is selected. So I don't know.
Well, let's assume the judge selects the CJA rep. Wouldn't that put you just back in the position of the judge sort of having a say in making policy about how you get paid and how much you get paid?
Yes, if the judge alone selected the rep. But if it were a committee, a selection committee, just like it's a selection committee to select the panel reps that's comprised of, a representative from different entities, the federal defender, the CJA rep, the district court judges, then maybe it would be much more neutral.
Mr. August?
Here's an idea, and it's based on the concept of the Fifth Amendment and the Sixth Amendment. If the function of defense counsel is to assure that due process is provided and to provide the effective assistance of counsel, and those are two concepts based in justice, why not put it in the Justice Department in a separate but equal position as to the Attorney General? Defense Attorney General, for example, somebody who would be in the Justice Department, who would be like in Montana, our Attorney General Mike Cotter, but have his co-equal part, just like Mike Cotter, but have defense counsel there. That's an idea based on, there's no Sixth Amendment right to an effective prosecution, but there is a Sixth Amendment right to the effective assistance of counsel. So conceptually, in the Department of Justice, separate but equal to the Attorney General.
Thank you.
Judge Jordan.
Yes, I want to drill down in just a couple of areas, and I'll start with you, Ms. Nakioka. I was also struck, like Ruben was, by your comment that those that are being represented by CJA panel, that you wish you had what the federal public defenders had, and I do want to ask you about that. Is it a matter of resources? Is it a matter of timely resources? Is it a matter of lack of camaraderie or somebody being able to, and I'm just going to ask you open-ended, what is it that's lacking?
Well, I think my main thrust, and it's all of what you just said, but my main thrust was the resources, the support staff. So if I were a federal defender and I had an appointment, I could walk into my office, call my investigator right then and there, give him a worksheet. I could call.
Let's stop there. So why can't you get an investigator? Or is it that you can't get him time?
But my investigator, if he's available, he's a private investigator, so I have to be sure that he's available to work on my case. I have to be sure that he's available and will accept the rate that the court is willing to pay him. I have to be sure that he's going to use. He's not going to use up his $800 in just reviewing the discovery so that I don't actually get the investigative work done. And that's not to say that I can't, file the motion and get the extra money to get him going. But I cannot just literally walk into my office and say, hey, Joe, come on over here and let's, get going on this case. I don't know if you can do that in the Federal Defender's Office, but I imagine it's that way. And I think it can be that way. So it's that kind of ease with which I can access the resources. I remember I got a call last year from the Federal Defender's Office from their mitigation specialist who was prepping the co-defendant for the case for sentencing, and I thought, dang, I wish I had a mitigation specialist who would take over all of the client family interviews, this, that, and the other. I enjoy that part of my job very, very much, so I don't know that I would necessarily hand it off, but there are times when it would be great just to have full-time paralegals, full-time investigators who are available 24/7, so I hear. That kind of ease would certainly make my job much easier. Instead, I'm typing up my declaration to request funds and trying to justify what I need them for. And I would rather not have to do that.
Do you think it would be helpful to have a system in which you'd have a panel administrator that would assist you in that? Many of the things that you've talked about, I look over at Mr. Cohen, and Mr. Cohen has access to an investigator, has access to mitigation experts. I assume, is that correct?
Well, just same access that Ms. Nakaoka has. I've also got to contact the investigator to see if they're available. And good investigators, private investigators, are in high demand. The good ones are usually overworked, and it's difficult sometimes to get their attention onto your case.
So the resource issue is both resource and a timing issue.
Right.
To have it in. Okay. All right. And the other thing that struck me, Ms. Nakaoka, in your testimony was the mentality of keeping fees down, and I want to know where's that from? Where's the perception from? Would it be within the judiciary? Is it within the culture? Where does that perception come from?
Well, I can't speak for other districts, and before I came here to testify, I did speak with some of the other CJA panel attorneys, and not all of them, not nearly a majority of them, but in the members I did speak with, they all articulated the same concern, that there is an inherent pressure to keep fees down. One attorney did have her fees cut considerably, and this was a post-conviction case. And that's harsh. She was working her case the best she could, to the best of her ability. She's a good attorney, I know her. And so she basically essentially donated her work. And this brings me back to this feeling that, this sentiment that somehow we are not entitled or should not be entitled to these resources, that we should, somehow our clients need to ask permission to get access to what they should have just free access to. And then there is a worry, I think in my state particularly, where there's a waiting list to get on the panel. I think some attorneys are worried they will be cut from the panel if they consistently exceed the statutory maximum, and that
by the judge in this case.
By the selection committee. The judiciary is part of that committee, so those are concerns I think that we could just alleviate by getting the judiciary out of the...
Can I ask one more question? Which leads to independence, and I think Chip affectionately referred to it as the Pete Schweda model of independence, maybe Schweda Horwitz after hearing the testimony today. But I do want to talk about it, because really what we've heard over several of the sessions, particularly the last 2 days, is independence, but not too much independence. And I guess I would want to see what the Schweda Horwitz model would be. In other words, what I'm hearing is things like the selection of the panel, the appointment, the voucher review would be outside of the purview of the judiciary, and yet there would maybe be a separate entity that would be within the budgeting purview, or under the umbrella at least of the judiciary budget. Is that what I'm hearing, or what would the model look like if you could build it today?
Well, you'd have a board of directors that wouldn't be beholden to the executive committee or the budget committee or the judicial conference.
And so who would they fall under?
They would be on their own, just like the Sentencing Commission is and the FJC is. They would have their own discrete budget. I think that they need the support of the judiciary. I don't see this umbrella organization being outside of the judiciary. I see it being part of the judiciary. I would recommend that judges be members of the committee, not necessarily all of the members of the committee, but that they lose the influence of the other parts of the judiciary that is looking out for the judiciary's budget. Because I think what you get now is even if the judges understand it's not a zero-sum game, that every entity is going to be treated differently, I still see competition between the entities within the judiciary competing for a piece of the pie, so to speak, and they want to make their pieces bigger and the pieces they're not interested smaller. And so I think.
So in other words, if Congress has authorized a rate of $144 to $148 an hour, that type of commission, that type of entity would be outside of the competing interests.
Correct, and they would make the recommendation to Congress to fully fund the statutory authorized rate.
All right. Ms. Horvitz, do
Yeah.
you have anything to add?
No, I mean, I think, like I said, in terms of review of vouchers and things like that, I think that could be a function that our CJA administrator and her staff does, but there would have to be a way of giving the Federal Defender's Office, she's under their umbrella, credit so that there were really resources within that office to handle that function. Because in preparing for this hearing and sitting down and talking to her, basically what she said is, well, we could do that, but we would need the resources. And right now, the way the Federal Defender's Office is looked at and funded is on a caseload basis. So there would have to be a way of giving their office credit for doing that work.
Thank you, Dr.
Thank you. Judge Fisher?
All right. Just one quick question, and Ms. Horowitz mentioned this a bit, but as you probably all know, Volume 7A of the Guide to Judiciary Policy generally talks about end-of-the-case billing as the best way to determine reasonableness, with some opportunities for interim billing with a suggestion of a 20% holdback. Ms. Horowitz, you mentioned monthly billing should be the norm. I'd like to ask each of you to tell me what the norm is in your district, and we've got some overlap here, whether you think end of the case is okay, or should there be monthly? We're now at quarterly in my district, and whether there's a holdback or not. Mr. Cohn, could you start?
Thank you, Judge. I don't know if there is a norm. I've talked to a number of different attorneys. Some do bill monthly or quarterly. Some, when they see that their operating account is running down, and they time it ahead for that, or at the end of the case.
You bill whenever you want. There's no district rule?
There's no district rule, not that I know of. It needs to be, your final bill needs to be in, I think it's within 45 days of the end of the case. And nobody's had a problem with that. The idea of the 20% holdback, though, really bothers me, because for an attorney to put in a lot of time and effort and to have that question mark of whether or not his efforts or extra efforts, or his or her efforts, extra efforts, might be compensated, it's a real drag on morale. We're in a tough job here, as Ms. Nakaoka, I think, pointed out, the difficulty that we have with gaining the trust of our clients, the problems that they have, the abuse issues that typically come with many of our clients, the drug and alcohol abuse, the difficulty that many of them have understanding concepts that we're trying to explain to them, this is tough work. And to have that question mark hanging in the back of our heads for the entire case, especially if it's a long case that's going to take a year or two to get resolved, I think is a bad idea. If the court has a problem, I think especially now with e-voucher, they're following you and they have the ability to track you as you're going along on a daily basis. Somebody can have access to that information because we're putting it into the cloud somewhere.
Only if you release it.
But
Not until you release it, right?
That's correct.
Yeah,
Thank you.
until you submit it.
So no.
okay, well, it's going into the cloud, and perhaps there should be a point where, you know, at a certain point, you know, they want to question it. Where are you going with this case? You know, kind of a case budgeting thing, so that you get approval, so that you're not having the question mark that what you might be doing could be pulled back at a later time, because that's going to really be bad for the morale of all the CJA's attorneys.
Mr. Schrader.
We in Eastern Washington, we can bill whenever we want. We are required to, when we know that the case is going to go over the statutory maximum, we're required to project what the full case is going to cost and fill out a CJA 26 that does go to the circuit to be approved. And since they've instituted that rule, I have never had one come back for the full amount. It's always been reduced. I don't know that in the end that it's caused a problem. I know in one of the cases, not on my voucher, but on 2 other vouchers, that's causing a problem right now for the attorneys. So that's the way we do it in Eastern.
When you say reduced, the budget itself was reduced, not the time that had already been put in. They're 2 different.
Correct. So, for example, if the court authorized 25, we asked for 35. We were authorized for 25. We billed 30. Then now the problem is for these 2 attorneys is justifying the difference between 25 and 30.
Ms. Nakaoka, do you have a thought?
Similar to the Eastern District of Washington, we don't have a directive on when to bill. If we are going to ask for interim payments, we do need to file the CJA form, and we do need to anticipate. My understanding, and I do this, is that we need to anticipate the full cost of the case to get that sort of pre-authorized, like Mr. Schweda. As for what practitioners do in Idaho, I don't know across the board. I know in my office, we're a tiny little office, and the cases usually run, approximately 8 months or longer, and so we ordinarily our standard practice is to do interim payment, so by month or every other month.
Ms. Horowitz, you mentioned it originally. What's the practice?
In my district, the norm is billing at the end of the case, unless the case is complex and extended and you've been approved for interim billing, which from what I understand from our CJ administrator is almost always approved. And in my district, most of the CJA panel attorneys are solo practitioners or are in very small practices. And so when your case goes for a year, 2 years, and you've plowed a lot of time into it, and you have a bunch of cases like that, you can run into some real cash flow problems. So that's why when we discussed it among our panel members, there were some suggestions that the norm be monthly billing. And I too find the withholding of the 20% for interim billing problematic, especially in my district where the circuit either always or almost always, from what I understand, approves the bill. There have been no instances, from what I understand from our CJA administrator, of suspected billing fraud on the part of our panel members. And in the last fiscal year, only 5 of the 600 attorney vouchers were referred to our standing committee for review. In other words, there was a dispute between the judge and the attorney. So in other words, we have integrity in billing in my district. And so the question is, why is 20% being withheld?
Mr. Hufstal.
In Montana, we bill at the end of the case. There was one occasion recently where we went to trial, jury hung, and so the government was going to retry him. So I asked for interim compensation on that case, and it was denied. And my sense was, reading the order for the denial, was that it's too unwieldy. I mean, it's got to go to the circuit, we got to, withhold 20%, and you can just wait until the end of the case. So.
Ms. Rowe?
Thank you. Where to start? Ms. Horowitz, I'm gonna start with you, and maybe stay with you, because I definitely have a few questions I want to ask you. You said a few minutes ago that when you are up for reappointment to the panel, that one of the questions that's asked, not you personally, but anyone who's a member of your panel, that one of the questions that is asked is how many cases have you had above the statutory maximum?
That's correct.
And when I was reviewing, well, let me start with that. Do you think that one of the reasons they ask that question is to determine whether or not the person bills outside of the ordinary bill, if their bills are too high?
Yes, I think.
Could you speak into the mic, please?
Sorry. Yes, I think that one of the factors that they're trying to look at and we don't have a process of reapplication, but a third of our panel is to be reviewed every so often. I think it might be every 3 years. And I think one of the things that particularly the judiciary wants to know is, do we have chronic excess billers? And if there's a discussion about the panel getting smaller, I think the judiciary wants to know who those people are to inform that discussion.
So if you were a person who had 4 cases, let's say 6 cases during your term, and 3 of those cases were over the statutory maximum, that would be a person who they might consider to be a chronic overbiller?
Well, I don't know. And, I'm new to this role as panel representative, so I haven't historically been part of these conversations yet. And so I don't know if 3 out of 4 cases would trigger it, or I know that there's somebody on the panel that has been on the panel for 20 years, and 99% of that person's cases are over the statutory maximum. So I don't know, what the threshold is where it becomes a concern. I don't know that yet, because I don't think I've been part enough of those conversations. But I'm not sure why that needs to be part of the calculus at all.
Well, would it be fair to say that it seems to be a negative connotation if you bill over the statutory maximum?
That's my take on the situation. And I also feel, even in a district where we have so much support from our administrator, from our federal defender's office, a bench that understands what we're trying to accomplish and all of that, I still find myself really looking critically at my own bills and saying, is the integrity of my billing going to be questioned or be an issue if I bill for this time? And sort of the judge inside my head is having some input into the way I do my bills.
Well, I think someone said earlier, there's a subtle pressure. Is that fair to say?
Yes.
A subtle pressure to try and make sure that yours isn't one of the vouchers that gets pulled aside for further scrutiny because it's above that limit.
Yes, absolutely. And in fact, I've made it a practice every time that I submit a bill in excess of the statutory maximum that when I submit a declaration in support of that bill, that there's a section about what I did to try to minimize costs in the case and what time I decided not to bill for, because I really feel pressure to make sure that the integrity of my billing is not in question and that it seems more than fair to the court.
Let me ask you this. That's a good point. The integrity of the billing. Because one of the things you just said a minute ago was only 5 or 6 bills have gone to the standing committee. I don't know if that's in the last year.
In the last fiscal year.
And you said that's because we have integrity in our billing. So it seems to me that you're kind of buying into that also, that if it's over the statutory maximum or if it's questioned, that's because there must be some question about the integrity of the bill.
I agree. I think that I am buying into it to some extent, and I'm not alone. Because I think we all feel, notwithstanding that a lot of these vouchers ultimately get approved, we get questions. Our CJA administrator gets questions. We're under the microscope.
And I'm also going to note that in your statement, it was clear that you had gone to folks, your fellow panel members, and talked to them about bills that had been cut, vouchers that have been cut. And I'm just going to just raise a couple of the reasons that you put in your statement. It says the work was reported to billing disparities between co-counsel on the same case. So obviously, if we're in the same case, that I have one of the defendants and you have another, my bill is different than yours. So that's something that was questioned, and or a reason for a cut, right?
Right, and that didn't necessarily mean that that the work wasn't done by one or the other, but a lot of it had to do with the fact that one person was a much better timekeeper than the other person.
So one person could have been keeping time for everything that they were doing, the other person was not, and yet when the court looked at it, they said, all right, well, Ms. Horowitz, you only billed $10,000, and Ms. Rowe billed $15,000, so we're going to cut her.
Right.
We're going to cut my bill.
Right, that has happened in my district.
So I think you would probably agree with me that that's not really an integrity issue. That's an issue of the judge deciding that they were going to choose the bill that was lower.
Right, or that somebody was a better timekeeper did not, that person was going to be dragged down by the person who wasn't as good a timekeeper.
But let's say I kept really good records and my bill was $15,000 and you were sloppy, so you should be the one who gets punished, right? But
right.
My bill, we're not going to push yours up to the 15. I would imagine that doesn't happen in your district.
Right. I mean, so we're trying to educate our attorneys that, it's not just yourself on the line. When you have co-counsel, the judges are going to be looking at all the bills and seeing how they line up and if it makes sense to them.
And there were other situations where people told you about where, and I think this may have been yours too, your situation, where the judge just said, I'm just not going to pay that much for this widget, if you will, for this defense. I'm just not paying that much. Good job, right?
That's correct. And the judge actually said, I expect you to do pro bono work. That's just something that attorneys should do. And that's the only dispute that I've had in my tenure on the panel. And I took it to our standing committee. And one of the things I did was I showed what pro bono work I do on federal cases and other cases. But to have me do the work and then at the end say, actually, you're not going to get paid, I expect you to donate this time, I just wonder how the judge would feel if we said, you know what, we're just going to dock your pay a month because this is a public service that you should do for free 1 month out of a year.
Let me ask you another question, and that's about the standing committee. You also told us about the standing committee, especially in your statement. And my question is, when the bill is disputed or a voucher is disputed by a judge and the judge is going to cut it and it goes to the standing committee, and the standing committee reviews it, the dispute, if you will, between the judge and the attorney, how does that usually come out?
What is the outcome?
Yes.
Well, so I've been on the standing committee for a year since I began to be the panel rep, so I don't have, again, a huge amount of experience. I did ask our CJA administrator, how successful is that process at mediating disputes? And she said, very successful. But I haven't done like a survey of our panel and said, hey, how satisfied are you all with this process that we have? And that's a question I would like to ask. But I can tell you, we're in the middle, or we just finished reviewing a voucher that was referred to the standing committee, and it was a pretty exhaustive process, where we went to the attorney and asked some questions, we went to the judge and really tried to get more clear on the judge's concerns and went back to the attorney, and then we took a position, and I think we've just submitted that to the judge and we're waiting to hear what the judge's response is.
So do you know if there are actually records kept as to what the how the disputes end? Is there, some of the money is placed back in the voucher, or the full cut goes forward? Do you know if there's any statistical data?
I'm sure that our administrator, because there aren't that many disputes each year, I'm sure she could pull that together. But I don't know what the numbers are.
And just one question, sorry. There aren't that many disputes. Does that mean that a person would have to choose to go to the next level? If they were to cut your bill and you were to just say, okay, I'm going to just accept that, I'm not going to go to the standing committee, then that just doesn't go any further, correct?
Right, unless the judge referred it to the standing committee first. So either the judge or the attorney, when there's a dispute about the bill, can refer it to the standing committee.
Thank you.
Professor Gould?
We have time for one last question?
Yes.
Wonderful, thank you.
Pardon me, I'm sorry, if I may. I got called to an emergency hearing down the 15th floor. I've got to leave in a couple of minutes, so I'd be happy to stick around for a few minutes, but I'm going to have to
Only
run.
one question, and actually we have to stop at 4 anyhow. So one of the things that I'm impressed by with this panel is the use of data. And in fact, the committee has some data before it looking at the percentage of representations in which the court gives the attorney an expert, professional services. In your 5 districts, that rate varies from a high of 54% to a low of 8%. So this is the percentage of representations, panel representations, where you or your colleagues are getting a professional service, getting an expert. You'll be not the least bit surprised to find out which one of you is at the high end, because we've learned that Oregon's nirvana since we've been here. But as I said, the low end is 8%. We also have 23%, 18%, and 16%. That's the current fiscal year, but that does track prior years. So in my experience, differences like that can generally be explained one of 4 ways at least. One is either attorneys aren't asking for experts, the court's not granting them, there's something different systematically about the kinds of cases that are in one district versus another, or there's some larger norm in the district that no one asks for experts. The Department of Justice doesn't really bring them in, the federal defender doesn't bring them in, panel reps don't bring them in. That happens rarely. I am curious if you all would be willing to hazard an explanation of what's going on in your respective district, because we do have one of the highest rates here, but we also have one of the nation's lowest rates. And since the rep from Oregon has to go, and since you're at the high end, maybe you could start with your explanation.
Thank you, Professor. Yeah, I think in our district there is a high percentage of the use of experts for a couple of reasons. The Federal Defender's Office, let me step back. When I first started going to CJA rep conferences, the national conferences about 6 or 7 years ago, I was really surprised when we had speakers up there promoting and encouraging us to use more experts, because the data shows when you use experts you get better results. Well, Steve Wax back here at home was preaching us just the opposite. Hey guys, you got to slow down. We're using experts too often. We need a better plan. If you're going to use an expert, we need a real concrete plan for what they're being used for. And he was specifically talking about investigators. But I think there has been a culture in Oregon of using investigators regularly, psychologists in a lot of cases. I myself, I start almost every case with a paralegal, because with the documents that we have now, having a paralegal who's really tech savvy and knows how to organize documents and review documents and summarize them and index them, an attorney doesn't have to be doing that. You can get a paralegal, and there's a big market for them out there who will do really good work for you for half the attorney rate. So I think there's a culture here that most everybody does use it, but we use that for different reasons. I do apologize. I'd be happy to answer any questions by mail or otherwise. I appreciate all of your work on the committee. I know it's a lot of work, so thank you very much for doing this.
Thank you for being here.
So the rest of you, whose numbers aren't quite that high, in fact, not even close, any explanations?
Well, I'm going to hazard a guess that Idaho is the 8%.
You're right.
Yeah. And I think there's a lot of different reasons for this. In speaking with with Kathleen Elliott, we talked about this specifically yesterday, and she said there was a discord or a disconnect between the national level, what the national standard what she understands the national standard to be, which is encouraging the use of experts and service providers with our district. I think the culture in our district is that we utilize these ancillary services for the special cases, the mega cases, or the cases that are going to trial. And there's a hesitancy to use services routinely. For example, Mr. Cohen said he uses a paralegal in every case. That doesn't happen in our district. We use paralegals, again, for large discovery cases or cases that are going to trial. Why? Because we don't feel like that we are entitled to use a paralegal in every case. And it's a cultural thing, and I think that maybe we need to, we also, we don't have a strong leadership in the CJA community. We are kind of on our own, and we look to our judges for what we are thinking is the appropriate use of resources. I've asked for resources and been denied, and I think that once you start getting denied, you get gun-shy about it. There's a chilling effect. Other attorneys see requests being denied, and they're like, why should I put the time in to ask? Because I'm going to be denied. So that's one of the things that I was commenting in my testimony, my paper testimony, is that the judicial involvement in management of resources can negatively impact the quality of representation.
I know we're over time, so if either any of you want to add something quickly, great. If not, we can end it at that. Oh, you want to answer? Okay. When the judges want it answered, we're going to get it answered. So for the rest of you.
Should I go ahead? Are you willing to tell me where my district fell?
Certainly. Western Washington, 16%.
Ooh, I'm very surprised by that. Well, I don't know the answer, but here's what I can tell you about what I do know. I think that the standards of practice in our district are very high, and we also definitely have a community. It's not the same as walking into a federal defender's office and having your colleagues down the hall, but it's close. We have a listserv that's managed by our CJA administrator. We get together for brown bag lunches. We're pretty tight that way and support each other. But what I would say about my district, which I think operates very well compared to a lot of other districts from what I understand, I think one of the places that we have the biggest fight is with expert requests. Routinely when I request an expert and I say, look, I've talked to the expert, this is what they charge, this is how many hours I think I'm going to need, this is the amount I'm asking for, I'm not approved for the amount I'm asking for, I'm approved for a lower amount, and I have to keep going. I'm just trying to think about what the response has been. I'm not sure if there's been an explanation or if it's just been the judge saying, crossing the amount out and just saying, I'm just going to give you $2,500 right now. And then I have to go back, several times sometimes. And I think the other problem is that the rates that these experts are going to get paid at makes it very hard to find the experts that you need to work at that rate. And I've had the experience where I have an expert and I have a really good experience with the expert, and then I go back a couple of years later on a different case and the expert's like, that was just too big of a pain. I had to wait too long for payment. I can make more money billing at my regular rate. I'm not available to do these kind of cases anymore.
Want the other two? The other two of you. And I will tell you, you're up both around, your districts are around a quarter of cases.
Well, I think it's, and this is really recent, it's become harder to get them. There's more denials. When there is an approval, the amount that's authorized is lower than what was asked for. There's a greater emphasis on sharing experts and even investigators, even though there's inherent conflicts of interest between defendants. There's still the imposition of trying to share an investigator. And I think then the complexity of the case, sometimes it isn't a very complex case and you don't need an expert. And also the strength of the government's case sometimes drives the decision on whether to get an investigator or get an expert.
And finally, Montana.
I think it's pretty case specific for us.
Would you speak
I mean,
into the
if-
mic, please?
Pardon me. I think it's pretty case specific for us. If you don't need an expert, then we won't ask for one. First degree murder case, we need a DNA expert, we'll ask for one. Fiber expert, we'll ask for one. But again, I'd mirror the comments of my colleagues. You know, it's limited to the statutory maximum, then you have to go back. And that causes a problem with the experts. They don't get paid. They don't get paid quickly. And it's just problematic. So
I must say, that confuses me. Are you saying then as a result, you're not going to find the experts because it's just too much trouble?
No.
Or, so help me understand this. If it's difficult to go get the expert, how does that then translate to a low rate of expert use?
Well, again, it depends on the case. If it's a murder case and we need expert testimony, then we will do what we have to do to get the expert. We'll file the motion, we'll provide a brief, we'll provide an affidavit, but it's an unwieldy process. You got to do it again, and the result is that experts don't tend to want to participate or allow us to, use them. In a basic case drug case where, the evidence is overwhelming, it really amounts to a plea agreement, sentencing issues, you probably don't need an expert, and so we don't ask for one. So it's case specific, I think, in our district.
I want to thank the panel very much for your candidness and your comments. It was really very helpful to us. If you think of anything else in the coming days or weeks, please feel free to send your comments to us. You can email them to us at cjstudy.fd.org. And once again, we really do appreciate all your time and your comments and help here with this. Thank you very much.